Great. Well, thank you all so much for joining us for Return to the Vault. I am really excited to start today's program by introducing your new host of Return to the Vault and new chair of the Return to the Vault Committee, Zach Taylor. So Zach practices at Manning Fulton. He's a commercial real estate attorney in Raleigh and in New Bern. He lives in New Bern with his wife, Kristen, and their son, Brian. And he likes playing golf. He likes to spend time on the coast. Um, Zach, do you have two children or one?
I do, yeah. So
Yeah,
I've got a little girl as well now. I need to update
I was gonna say, wait,
that
I think there's
bio.
another one.
Yeah, need to
Okay,
update that bio. Yeah.
that's right. Okay, Brian plus another one. Okay, so Zach is he's a member of the council, and as we go into a new bar year, he is stepping into this role of chair of the Return to the Vault Committee with help from Jacob Parrott, who's also on here. So thanks so much for stepping in, and I'll just turn it over to you, Zach.
Mary, thank you so much, and we sure will try to uphold what you and Kyle have done, and others coming before you in maintaining the status quo for Return to the Vault. Excited to be here. Excited to lead this committee. As Mary mentioned, I would also like to introduce another new Return to the Vault committee member, Jacob Parrott. Jacob is an attorney in Shell Bray's commercial real estate practice out of Greensboro. And we're happy to have everybody with us here today. And we look forward to, like I said, continuing this great Return to the Vault tradition. If you're new to Return to the Vault, it's a program of the real property section. It provides practical, timely education and connection for real property section members, inspired by the collaboration that once happened in the vault at the Register of Deeds offices across North Carolina counties. Return to the Vault brings us together once a month on Zoom to share ideas and practical insight. The programs are not offered for CLE credit. We tried, we were unsuccessful, but they are recorded and available, and they're a great resource on the Real Property section homepage to watch later. Just Google NCBA Real Property section, scroll down to the bottom of the page where it says Real Property Roundtables, and click on Watch Now. Also, be on the lookout for Return to the Vault on demand blog posts on the Real Property section blog. Um, Return to the Vault on demand, that's an extension of Return to the Vault and gives us a flexible way to share some timely updates and focused guidance on the blog when issues arise between live programs. So that's just another resource for our section members. Getting to today's program, today we're excited to hear from Troy Crawford and Maggie Davis. Troy Crawford is the managing counsel for LM Title. Prior to heading the title agency, he worked for Lawyers Mutual as claims counsel, focusing primarily on real estate fraud and technology-related claims. In that role, Troy routinely taught CLEs and other professional education programs for national, statewide, and local organizations. Before joining Lawyers Mutual, he worked at Investors Title as a claims and subrogation counsel. Troy began his career with a small Garner NC law firm where his practice concentrated on commercial and residential real estate transactions and litigation involving real property. So, welcome, Troy. Maggie Davis is a partner at Magnolia Legal out of Durham. Maggie's practice focuses on resolving complex title issues that arise in real estate transactions and litigation. She works alongside attorneys, title companies, and clients to clear a path forward. So, as y'all can see, we sort of have this, the theme of our program today is when we disagree. We've got the private practice side with Maggie and the title company side with Troy. So, we're excited to hear that. Troy and Maggie, they will explore what happens when the title issue is real, the answer is not obvious, and experienced attorneys reasonably disagree about the best path forward. I think all of us have been there before. Using real world issues involving ladybird deeds, affidavits of heirship, old deeds of trust, access rights, and other familiar title questions, They will discuss why attorneys, title counsel, and underwriters may view the same problem differently and how professional judgment and risk tolerance shape those perspectives. Afterwards, Michelle Church, VP of Operations and Title Counsel for LM Title, will follow up the presentation to share some information about our sponsor, LM Title Agency. And we thank LM Title Agency again being here. Troy and Maggie, thank you for being with us today. We look forward to hearing from y'all, and I will turn it over to y'all.
Okay, so appreciate that on behalf of Maggie and Michelle. Appreciate being invited. Also want to thank my wife. Today is my 26th anniversary, and we're on vacation, and she's still letting me log on and do this. So I'm very appreciative that she has allowed this to go forward. But what inspired this program was for anyone that attended the annual meeting in Asheville, in which Maggie gave a very excellent presentation. She started out a little nervous, and then she just absolutely, I thought, did an excellent job. Well, there's a little discussion that happened about the validity of Lady Bird deeds. So if you were there or you watched online, there was some kind of disagreement, and Chris Birdie and myself started talking a little bit. Everybody had a good time, and so when we were asked to do this program, I thought it'd be kind of a good way to just talk about some things where we disagree. Now, Maggie and I, when we first talked about doing this program, we figured it'd be some days where we really did disagree with each other a whole lot, and sometimes we have different opinions. But for purposes of this, we're going to try to maybe disagree more than maybe naturally would on some of the topics, or take more extreme positions than maybe what our natural positions are, just to make the discussion a little bit more back and forth. Maybe Dan Aykroyd, Jane Pauley, for those of you that are old enough to remember that type of program. Maggie, do you want to add anything to that?
Make it like debate club in high school. You have to pick a side, even if it's not natural. And to add on to the bio that Zach gave about me, I've been a closing attorney prior to starting my own practice. To do the complicated things, I've been a closing attorney for a long time. So I will be speaking from that perspective as well, and pushing back on Troy, the title insurance provider.
Alrighty, so the first thing was Lady Bird deeds, I believe. That's kind of the low-hanging fruit where we started out. What inspired this program?
Disagree about Lady Bird deeds, Troy, don't you think? I mean, I'll get onto my soapbox. I don't know if you guys can see, but right over my shoulder there is the bundle of sticks that I like to remind people that I have in my office. And I just feel strongly that you put somebody's name on a deed and you put it on the public record, you let them, if you're not giving them a stick, you're at least letting them touch the sticks. And when I'm a closing attorney, I'm getting more signatures rather than not. And so my soapbox about Lady Bird deeds is that they are largely useless, I think, for the purposes that our clients think they're getting. Right? I think clients walk into your office, our offices, and say, I want this to pass to my children or whomever. I don't want Medicaid liens attaching to it. How can I do that? Let's do it by a deed. I don't want to deal with an estate plan or even part of an estate plan. And all of the possible outcomes aren't considered, and you wind up with a hot mess sometimes.
So I would agree. It's like Maggie is saying that she has a bundle of sticks, and that you're just not getting you're not really getting a stick. I'm all there, and I think that her position would be you're basically trying to do a will without the formalities of a will and put it on the public record.
That's right.
I do not pretend to know much about Medicaid estate planning and why it's done. I know in parts of the state there were two different methods. There was a joint tenants rider survivorship deed where someone would give their kid a 1% interest and put $2,000 worth of excise tax stamps on there and say that was a good faith transaction. And in other parts of the state, the Lady Bird deed was done. And now there's all types of these hybrid combinations where you're getting very confusing. And they're done for Medicaid planning purposes. But I think if I was on the Court of Appeals or a judge, that I would find them valid. I mean, so basically you're given a life estate There's clearly a remainder interest is vested under North Carolina law. I don't think there's any doubt about that. So you're giving a vested remainder interest, but it is subject to the power of appointment. And so we do have a Power of Appointment Act, and we do have some case law that's relatively favorable that is recognizing these. And again, I mentioned this at the meeting. The case that I'm able to remember more than either one is from 1864, and it's Troy v. Troy. Now it was a will. Pardon?
I wonder why you can remember that one so easily.
Yeah, that one is not hard to get. There's a lot of people in my family that have been in the court system, but usually they're standing next to the attorney as the defendant and not there. But the Troys were a relatively wealthy family, and they were able to litigate to the North Carolina Supreme Court, and this interest in land was recognized. So I do think it would be a valid interest in land. I agree that you're not getting that much. And in the ideal world, I personally would love for the legislature to step forward and go one way or the other. Because one thing that Maggie and I did talk about is as real estate attorneys, we have some pretty hard and fast rules, but we love them in our industry because we know what the rule is. So like the pure race statute that North Carolina is pretty much on board with, it can produce some harsh results where fraudsters are able to get away with stuff. Where things that just aren't right happen. But you know what? When I search title 15, 20 years down the road, I can rely upon the public record for, pretty reasonably. And so I like hard and fast rules. Now, what happened at the meeting was I was trying to bait another title company to step out there and identify themselves, and they declined to do so. There are two title companies or two underwriters in North Carolina that will insure Lady Bird deeds. Combined, those two companies have approximately a 35 to 40% market share. But then every other underwriter in their state will not insure that. And when I mean will not insure it with both without the life tenant and the remainderman signing off in the transaction.
Right. That's fundamentally the underlying issue is if you're trying to have the grantor on the deed be the sole actor, right? I mean,
well, I would say the life tenant.
Sorry, say that again.
I would say the life tenant, because in theory you could give the life estate remainder interest to two separate people, and in the will context, the Troy v. Troy, that is what happened. Is husband left the property to his wife for her life with the power of appointment over the kids' remainder interests. So, but yes, would you want can we do it without the family signing? And what I would say is that in the title world, while I do think it's a valid estate and would be recognized, that's when it gets very scary. Because if you now have family members who will not sign, then we're getting into family drama. And that's the whole reason we all went into law school is that we did not want to. I mean, when we came out of law school, while we went to real estate rather than family laws, we really take a smaller paycheck, not to have to deal with family drama. And so we want to avoid it. But there are two title underwriters in North Carolina that will insure those transactions. So if you come up to one and you do a little bit of calling, you'll find somebody that's willing to insure those transactions. But when I said there are two that will do it, and they have between 35 and 40% market share annually, that means you have anywhere from 60 to 65% of the title underwriters that will not touch these and are adamant about that. So as an attorney in private practice, Maggie, what would you do in that situation where I can say I can get insurance, but I know other people will not insure it?
For me as a private practitioner, I would really have to stop and think. I mean, I had one of these come across my desk last week. And, obviously I'm not a title insurer, but I have to think about my own risk, whether or not it's an insured risk or not, because it's my reputation, right? And I'm going to have to deal with the client either way. But the one that came across my desk, and it's funny because Troy and I have been preparing for this, and I was like, really, are Lady Bird deeds this much of an issue? And then boom, one landed on my desk. So, gentleman's calling me. He lives next door to his mother-in-law. His mother-in-law and father-in-law is deceased, own houses side by side. In 2019, so 7 years ago, mother-in-law and father-in-law executed two Lady Bird deeds, retaining the enhanced life estate, giving the remainderment interest to their two daughters. Two daughters are now both married. One of them is pregnant and married to the gentleman who called me, and they are looking to do a cash out refinance on the house that they live in so they can do some refurbishment before the baby comes. Other sister is going through a gnarly divorce, like gnarly. And talking to this gentleman about how to work around this issue was just, I felt for him, right? Because this was 7 years ago. In-laws were in their 60s at the time, were in good health at the time. The daughters, the remainder interest holders, from what I can gather, were maybe in their 20s and wholly unmarried, right? So I cannot fathom that mom and dad, or mother-in-law and father-in-law, transferred this interest with the concept that a future estranged spouse was going to be able to hold up what they could do with these houses that they own outright. And I mean, this guy, he went in circles for 30 minutes. What about this? What about this? What about this? And I finally was just like, you need a private loan that has got nothing to do with this property, right? I mean, you got to take a loan against your IRAs or against something else, man, because you are not doing those renovations with a refinance. Because not only was estranged brother-in-law not willing to sign, nobody knew if he even knew of this interest in property. So can it get brought up? Will it blow up the divorce negotiations? And because they were going in circles with sister-in-law about this divorce she's going through and trying to get her estranged husband to sign, she stopped talking to them. It's just a mess, right? Like, it's just such a mess. And if it had been dealt with in a will in lieu of this deed, you wouldn't be in that situation at all. They wouldn't be in that situation at all.
And from what I understand, Medicaid now has changed the eligibility criteria, and again, that's outside of my thing. But I understand now, at least talking to the estate planning bar, that these may start becoming less common as tools. So and hopefully so, or we have legislation step up and just go one way or the other what you're actually getting. And I'd prefer either one of those scenarios would be fine with me. You want to transition now, or I'm sorry, Maggie, go ahead.
Well, I was just going to give a strategy I kind of say it jokingly because you asked me what I would do, right? I always say more signatures rather than fewer, right? I mean, heck, Troy could sign the deed to my house for all I care. Is it relevant? Is it legally valid? No, but more rather than fewer, right? I mean, so without the joinder of all the people on that deed, it's very hard to convince me to move forward with the transaction.
And I'm in title insurance. So you say, should someone sign? I mean, my default position is going to be yes, no matter who you. It doesn't never hurt from an insurability standpoint to have someone else on the deed, even if they don't own anything. So yeah.
Okay, so the other topic we kind of wanted to dive into is estates because it's just a minefield, right? I mean, there's so many things that go wrong or could go wrong in estates. The other part of my practice is estate administration. I affectionately call my practice Death and Dirt, but it really is an interesting to do both of those practices, areas side by side is really interesting. And I want to clarify kind of as we go through talking about this. First of all, I'm going to take the representation of the estate personal representative's perspective, and Troy's going to take the real estate closing attorney or title insurance company's perspective. But when we talk about an estate selling property, right, like that's just the vernacular for, because it's a vernacular for inherited property that is being sold within 2 years of decedent's date of death, right? So like the last vested owner died within the last 2 years, therefore our statute of limitations for creditors' claims is still open. probably we have in an open estate. But very, very rarely, when we say an estate is selling the property, is it actually the fiduciary of the estate selling the real estate in their sole capacity. So I just kind of wanted to clarify that because you see it cause confusion all the time. Those of us using Qualia, those of us using SoftPro, right? Like you have a contact for the actual individual sellers, you have a contact for the personal representative of the estate, and it all just gets mashed in there and they're all just sellers and the estate is selling it. But that's not true, right? We all understand upon the death of the vested owner, ownership transfers to their intestate heirs at the moment of their death, subject to the proper probate of a will. So yeah, we're talking about the sale of that real property within the 2-year statute of limitations.
And subject to defeasance to pay the claims of creditors too, so it potentially
Correct.
could come back in.
Right.
One clarification too is there's a little quirk in the law. It's if notice is not first published within 2 years. If you actually publish notice, even within more than 2 years, you still have to worry about claims of creditors. So if you publish the notice within 2 years, the estate is still open for whatever reason, then we do worry about claims of creditors, even though it's outside. It's been more than 2 years since the date of death, because you had a response.
That?
Pardon?
Why would someone do that? Let the 2 years.
Well, sometimes it. Or it's just taking 2 years to administer the estate. I mean, what is? How often do you? I mean, how often do you start an estate and then someone realizes in there over their head, or they get lazy, they can't emotionally deal with it.
You're right. They haven't run notice to creditors. Blah blah blah. Got it. Yeah. I see what you're saying.
Or they did run notice to creditors, and all of a sudden crap started coming in, and that's the other situation that they did not know about. When I was in private practice, and somehow I did a couple of these, and then more of them just started coming in the door, where I would open an estate, a full estate, and for whatever reason, a lot of times they didn't open a full estate, but they would publish notice to creditors, and mom had a QVC habit. Was more than one thing that happened, and suddenly the estate was very much upside down, and they weren't getting anything. They had no motivation to move forward. But yeah, other thing about the comments you made about when it's deeded to the when the will specifically deeds the property to the executor with the intent to sell the property. Whenever I give CLEs, this is like my favorite slide. We couldn't do it here because the Bar Association are the absolute copyright police on everything. But I would usually throw a picture of Meatloaf on the screen, not the dish, but the horrible singer that my roommate in college loved to an abysmal level. And I will put on there, you're supposed to, what we look for when we're asked to insure these is that it deeds the property specifically to the executor. There's an express command to sell, and then there's a specific directive of what to do with the proceeds. And the reason I throw Meatloaf on the screen is that 2 out of 3 ain't bad. And so if you can get 2 of those 3, in my opinion, it's going to be insurable and marketable every specific time. But where we get into fights with people all of the time is when there's some general language that the executor shall have the ability to sell the property without joining in the heirs. I'm assuming you see that pretty often, Maggie. Is that right?
Yeah, I was just pulling up a will I've drafted, in fact. I hereby grant to my executor, blah, blah, blah. Such power may be exercised independently and without the prior or subsequent approval of any court or judicial authority to sell, transfer, or convey at public or private sale on such terms and price and the manner as the executor shall deem best any real or personal, tangible or intangible property. I'm paraphrasing slightly, but that's super, super common language you see in a will, right? And I have definitely had individuals, executors under a will with that language state that they have the authority to, in their sole capacity, sell the property as part of the corpus of the estate. It's in every will. I'm gonna say, subject to North Carolina law, et cetera, et cetera. It seems pretty clear, right? My executor has the power to sell whatever they want. I give them full discretion. That's the whole reason, as the person drafting the will, executing the will, that I went about this, because I want them to handle everything. Why wouldn't that language be enough?
So, I mean, I think it's just clear North Carolina title passes immediately on death. There's a specific statute directly on point. A lot of times people will incorporate those powers by reference, by uniform referencing the Uniform Trust Code. But again, the title is no longer in the estate. Title vests immediately on death to the heirs, either intestate or when the will is probated, the probate heirs. And it can only be divested if it's necessary to pay the claims of creditors. So again, this is one where I would love some legislative clarity, because you do, in theory, have some contradicting language. And then people will also say that, well, the will says this. I mean, well, the will can say that, can try to give away property that the decedent never owned. Just because the will says it doesn't mean it contradicts North Carolina law. And so, for sake, and generally speaking, or not generally, but very frequently, the beneficiaries of a will of real property are different than personal property. And it would be subject to a great deal of abuse, especially if the executor is someone that's getting the personal property and not a deeded piece of real estate.
Right. I'll be honest. This one, it's hard for me to be a contrarian on this one. But for people who draft wills, it is really, really important to note, like you say, Troy, that title vests, and so the on death, and so even with the probate of the will, the executor hasn't gone through the process to pull that real estate back into the assets of the estate, because that is a special proceeding. And there are times when it absolutely should be done, but you have to petition the clerk of court for that right to bring the asset back in, and you have to prove why.
Now, there is one person in our industry that is exceptionally very well respected that has some type of workaround, and that workaround is that they will have the beneficiaries of the, let's say, a will, rather than having them sign the deed, he'll just have them file a consent to the sale and file it in the estate file. And my point is if you're going to have them sign something, why not have them sign the freaking deed, and there's no question whatsoever?
Right.
That resolves it. And we would all be comfortable with them waiving warranties of title or something like that. I mean, there's just, the industry, this is one where we could, as title insurance, and we get a little bit more comfortable if they're, for some reason, one of those beneficiaries is reluctant to join in. But again, this is one where I think we are in complete agreement. We're trying to discuss the differing sides on there. And this is one where I wish the estate planning bar would do a little bit better job explaining to their clients that while this language is in here, it really is just not going to be recognized, at least not in North Carolina.
Right. And I also think it's super important when you're drafting a will where the person is leaving 10% to this charity, 15% to my second cousin in Kansas, et cetera, to have that very, very clear provision. It's only a couple sentences long that says, I leave all real property to my executor to be sold and add to the principal of my estate. All proceeds add to the principal of my estate. But that really leads us into the next topic, which is who gets the money and why. Especially when there are creditors, because we've said multiple times already that the title vests, and those of us that cut checks after we do a closing know that you cut the check to the grantor, right? And so if we know that the heirs are the vested owners, and we're only having the personal representative of the estate join to sign off that the estate doesn't need it, right? Then why would who gets the proceeds even be a question?
And this is one where I think my industry as at fault, but it goes back to that we do not like drama at all. And so we do not want to get caught into an estate battle because, again, next to family law, that can't be the most important issue whatsoever. And people can argue about things for the sake of arguing. I think the law was clear on this case. Now, when I was in private practice and I would call title counsel, I was always amazed. Like, these people are geniuses. They're just geniuses. And then I became one, so we knew that went out the window. But you see it like, how in the world could they memorize all these statutes? Well, you do it a lot. And the one that the statute that I will always remember until I start getting dementia is 28A-17-12. And that is the statute that basically says that property passes free and clear of the claims of creditors in these particular circumstances. And the big one is that the notice to creditors has run at least once. And to me, that is illogical. I don't know why you don't need to have the full notice period to run, but the statute is directly on point and is clear. And the executor joins in, or the personal representative, if it's joins in the conveyance. And so that is 100% clear. But and if it was to be litigated, then I'm very confident that the good faith purchaser for value from the sale would be protected from that. But I just said the words that if it is litigated, and when you deal with family law drama, it is sometimes will be litigated, and our premiums are just not based upon litigating mess, especially in there. The other consideration, and we've had this happen in a couple of matters, which we've seen claims come in, is that it's hard to tell who's a related party, by the way. And so, people have different last names. We're not in the Russian where my middle name is my father's name, where I can start placing things together and figuring out who's related. And so we've had things where potentially property is passed on the maternal line down, and someone's buying that we thought would have, by all accounts, would have been a third party that was not related, that suddenly now has a little bit of knowledge of the transaction, and then we're getting drugged back in there. So for that reason, every title underwriter that I'm aware of who gives us agents will have a standard commitment line when there's an estate that, in regards to this estate, don't have the things you're supposed to do. And out of the 6 things on there, number 5 is that the proceeds were not necessary to pay claims of creditors or were made payable to the estate. And so when you're from the practitioner side, Maggie, if you got that, if you're sitting there as a closing attorney, you're going to either certify those claims were not necessary to pay the claims, those funds were not necessary to pay the claims of creditors, or you're going to make the check payable to the estate to satisfy the terms of the requirement. Is that
right? And I'm going to argue against myself even here right now, because if I am the closing attorney, how am I certifying what creditors' claims there are? I mean, there's the instance where the notice to creditors has run, the 90 days has run. I can see the assets in the estate because the inventory has been filed. I can see what claims have been filed, etc. And I can give a best case scenario, or I can, an educated opinion on that. But if we're going by the statute, which obviously is normal and right, but it only has to have run once. So the way notice to creditors work, for those of you that don't do estate administration work, you publish it, it runs 4 times, once a week for 4 weeks consecutively. And then there's from the date of first running, that starts the clock for the 90 days. So by doing that, we have shortened in the practical sense, what we've done is we've shortened the 2-year statute of limitations down to 90 days, right? And so if we're closing the transaction in that first month, while the notice of creditors is still running, we have not let the statute of limitations run in any way, shape, or form. And so in order to meet that requirement in the title insurance commitment that Troy is talking about, how am I certifying that the title wasn't needed, or that the house wasn't needed to pay claims? I mean, Medicaid's probably not rushing to put their lien out, right? I mean, they will, but not in that first week or two. But
Yeah, and the notice only gets rid of unknown claims. I mean, there are times when there are known debts, they're not wiped away at all by the writing of the notice if the executor should have had notice of that. So it's a
right, because there's the notice, there's the creditors that actually do the things to file into the estate as a claim. And creditors of the estate are also those debts known by the executor or the personal representative of the estate. So that means they received a bill. It's not necessarily filed. They haven't told you about it, but they owe Costco credit card $572. You don't know about it, but the executor knows about it, and that's absolutely a debt of the estate. I tried to come up with a bigger number, but 572. I mean, that's like half a trip to Costco. But
on there.
but from the executor, from the attorney who represents the estate perspective, I do not want you giving that money to the estate, right? You being the closing attorney. I do not want it cut to the estate because now my client, the estate, has to pay $4 per thousand of assets that run through the estate. So you're cutting me a check, cutting the estate a check for 300,000, and now we're having to pay whatever that is. I'm not doing math quickly enough. It does cap out at 6,000 in fees, but that's a possibly 6,000, or even if it's a $1,000 or $2,000 cost that my client wouldn't have to pay if I could convince you to cut the checks straight to the heirs.
So, and this is one where I think which title company you work with has an advantage. And one of the things with the proliferation of JVs, and there's some that do a great job and have attorney on staff and are able to work with you, but there are other ones that you're just not going to be able to work with them in this scenario. But when I'm asked to insure this, and I see several other title insurance attorneys on this call, and I'm comfortable with everyone that's on this call the same way, is that we would kind of do a holistic approach and look at it. And we have the ability to change that requirement. So whenever you have that situation, if you will give us the facts, hey, the notice is run the whole time, or hey, this family, they have plenty of money. Like this is not going to be an issue. They weren't the big one I worry about are the hospital bill and Medicaid, because those are going to be the two known creditors are not going to be wiped out. And usually when you can get to where I'm comfortable that those guys are going to get paid, then I'm willing to modify that requirement and just delete the requirement, the check, just delete that portion of the requirement in there. But again, that requires a little bit of research on your end. I'm going to probably ask a couple of questions and follow up, and we can change that. And so that way your client saves the money. The estate administration attorney will not cuss you quite as much as part of this process. And we can get along a little bit better. But unfortunately, when you're doing these types of transactions, they can get to be they can just be time sensitive because a lot of money is involved. And again, when we're making a few $100s on the transaction, if we have to defend something that will cost tens of thousands of dollars in legal fee, even we know we're going to win. I mean, we know we're going to win, but the math just does not work out with that little bit more.
Hey, Troy, we just got a question from Kim Steffen over in Hillsborough. Hey, Kim, she's my first boss as a lawyer. She says, doesn't an estate indemnity affidavit meet the need?
Well, again, the estate indemnity affidavit is going to give me some insurances. I mean, the person is going to say that, but it's not going to change the title insurance requirement. So, I mean, it's just like a lien waiver. You have an indemnity affidavit. And I mean, I was subrogation counsel for a title insurance underwriter. Indemnities are nice. They usually actually help you avoid getting the debt wiped out in bankruptcy court, but it doesn't make it suddenly collectible. So while the affidavit is nice, I again, just based on my background, I'm not the biggest fan of affidavits versus elimination. So the affidavit gives you some reliance. It probably would allow you to assert good faith, but it doesn't suddenly make the drama collectible at all.
I have two great examples on estates that I'm working with right now. One, the property's being sold today. There, on the public record, looking at the estate file in Wake County, you can see that there's $290,000 in liquid assets, right? And so how, depending on, how many creditors, it well, also more than 90 days has passed, but you can look at it and get some level of assurance that there's liquidity in that estate should claims come up, that you're willing to rely on that indemnity affidavit or not, right? But for me, I'm more comfortable with it as a practitioner, as a closer. I've got another one. We're selling property up in, sorry, I'm looking at Granville County. I'm looking at my map. It is the only asset. It is the only asset in the estate, whether or not there are debts. If I'm that closing attorney, I'm paying the proceeds to the estate, just because there's nothing else that would cover debts, especially if we're within those 90 days.
Yeah, and the problem can be is, again, when the real property is not being distributed the same way as the personal property, and so people are going to get different shares. But again, that's an estate problem. That's not necessarily a problem I want to get involved as the title underwriter. If there are known claims that have been filed, absent, I'm getting very comfortable with their other assets that for some unique and strange reason cannot be paid out of the estate before closing. And it would take then I'm gonna want known claims to be wiped out. Mary or Zach, how much longer do we need to go? I don't want to go over because it's everybody's lunch hour, and I want to get on the beach because it's actually cleared up.
Right. I was just going to chime in. It is 12:46. So if y'all just want to wrap up, I don't know if y'all have a couple more things you want to cover here, and then we'll sort of turn it over to Michelle.
Let's do the foreclosure very quickly, Maggie, because that is the one thing that we actually do disagree on completely. All there.
So, Troy kicked this to me. Foreclosures. What do you do when the junior lien holders are not noticed? I responded that you run screaming. No. I believe junior lien holders should be noticed in order to wipe out their interest. Again, as a closing attorney, I have not touched foreclosures, so I see the foreclosure and it freaks me out. So right there, my risk tolerance has dropped considerably, right? Because I'm freaked out. But Troy, you disagree.
Well, so I mean, I think that people will talk about the constitutional issue and lack of notice to a junior lien creditor, and this is where a practical consideration comes in. All of your large foreclosure firms in North Carolina, whether it's the Rock and Scott, the Shapiro and Engel, or their derivative now, Hutchins, you go down. I don't know any of them that provide notice. Again, in the ideal world, absolutely. If I was a foreclosure attorney or a substitute trustee, I would provide that notice. However, I'll insure them all day long, and I think everybody else in our industry will. And the way I get around the constitutional argument, there's this great tool that our statutes allow that this is not a naked notice. If they want notice, they can file a request for notice on the public record. Now, I will not insure over that. If someone has been asked to provide a request for notice, you're going to show me they were provided notice, or we're going to get some type of a release or a quit claim or some nature like that from that individual. But it just as a practical matter, I don't know of any of the larger foreclosure firms that routinely provide notice to junior creditors, either judgment creditors or to people that are second, third position deeds of trust. And in my opinion, that transaction still would be able to go forward if for no other reason than practical matters, it shut down the state, the stream of commerce in the state if those foreclosures were not valid.
And the thing that gets me about that rationale on the notice to creditors, I mean, I hear it, but I'm like, if I have recorded a second deed of trust, I understand the notice to creditors on a judgment creditor, you would want to get that recorded over. Okay, fine. But if I have recorded the deed of trust, it's a race state. Why wouldn't that be sufficient to require notice to me? Again, I hear everything Troy's saying, and I would follow the title insurance company's advice on that, obviously, but boy, is it nerve-wracking.
Again, I would love it to be done, but it's not. It's just not. Hey, I know where you get that PowerPoint slide from. I've used that one before out of this week. Go ahead.
All right, Troy, it's been fun disagreeing with you.
You too. Thanks. Michelle, you want to kick it off?
Well, Troy, Maggie, thank y'all for being with us. Thank y'all for that great discussion. I think we'll just save any other questions until after Michelle tells us a little bit about today's sponsor, LM Title, and I will turn it over to Michelle Church.
Yes, hi everyone, and thank you, Zach, thank you, Maggie, thank you, Troy, and thanks to everybody that's here. For those of you that don't know, I am Michelle Church. I'm one of the attorneys along with Troy over at LM Title, and we appreciate the opportunity to sponsor today's Return to the Vault. LM Title is a wholly owned subsidiary of Lawyers Mutual, for those of you that didn't know, and we are about to celebrate our 8th birthday in a month or so, and I'm just shocked that it has gone that quickly. But just to let you know that our team of 18 are available every day to assist with title questions, underwriting concerns, prior policy searches, and just practical guidance on real estate transactions. We represent 5 national title insurance underwriters, and that gives us a lot of flexibility when helping attorneys navigate those difficult issues that seem to be popping up now more than they used to for some reason. But as part of that, we believe education is one of the most important steps. So on the 3rd Tuesday of every month, we host a free virtual real estate focused CLE at noon. And if you've missed any and you want to catch them, most of them are available on demand on Lawyers Mutual's website. And you can also see them on our website, and then it will link you over to Lawyers Mutual's website. And some of the things that Troy and Maggie just discussed are going to be brought up in a CLE that we've got in just a couple of weeks, August 18th. Troy is actually going to be speaking on estates and real property. So if you're interested in that, please join us. You can go to our website and register. I also want to put Parapalooza on your radar. It's coming up in October. It's one of our signature education events. Sharon and I put so much time into it. It is geared for real estate paralegals and support staff. I mean, they play such an important role in real estate transactions in the law firm. So we hope that you'll encourage your team members to attend. We do have a giveaway. And if somebody wants to announce who that is, but you'll be getting a $50 Amazon gift card. And we're also going to make a donation in your name to the charity Able to Serve. And thanks again, everybody, for being here. And we look forward to working with you. And we appreciate everything that the real property section is doing for us real estate practitioners, whatever environment we might be in. And the winner is Tracy Belk. Hey, Tracy, hope you're doing well. And I will get up with you after sometime later today to get you a gift card. So thanks, everybody. And I'll turn it back over to Zach.
Michelle, thank you for that. If anyone has any questions, feel free to put them in the chat. I don't think there's any unaddressed questions right now. Feel free also to unmute if you want to ask directly. If you think of something later, of course, feel free to reach out to Maggie, Troy, Michelle, or myself, or Mary as well. Don't think. Give people a second here for questions. Like I said, if something comes up later, feel free to reach out. Thanks for joining us, everyone. Thanks again to today's sponsor, LM Title Agency. Return to the Vault will be back next month on September 2nd, where we'll have Matt Waters giving a community associations update, what real property lawyers need to know in 2026. Also, be on the lookout for other real property section events heading into the fall. We've got a good schedule planned this fall, and we're looking forward to it. that being said, we hope everyone has a great end here to wrap up their summers, and we will see you next time. Thanks, everyone.
Bye, everybody.